We will start. We might have some more people coming in, but I think we have quite a lot on the program, so let's kick off. I would like to start with a little introduction. My name is Denisa. I'm an attorney at law, qualified here in the Czech Republic. I studied here in Oslo, in Norway, and I worked in multiple countries. I'm primarily an IP lawyer, but I also did quite a bit of different stuff which I consider related to IP, among other things, software and licensing, commercial and contract law, data privacy, and also litigation. I have about 15 years experience practicing law in the government offices, in international law firms, and also lately as an in-house consultant to tech companies. I would be very happy if we could do a little intro also for yourselves, if you would be so kind and just tell me your name and where you're from and why you picked IP law, or why do you think IP law is interesting for you. So we can get the mic going.
Start from this side.
Mm-hmm.
Okay. Hi, I'm Pram. I'm from Indonesia. I'm interested in intellectual property, especially for copyright.
Okay.
Yeah.
All right.
Yeah, that's all.
Thank you.
Sorry?
Thank you.
Yeah, thank you so much.
Hi, I'm Gabe, and I'm from India. So I graduated in 2021, and I have 9 months of experience, but nothing much in IP, so I would like to learn more today.
Okay, perfect. Thank you.
Hi, my name is Mariam. I'm from Georgia. I'm a law student as well. I graduated a month ago, and no, I never had any experience in IP law, and I'm really looking forward about this lecture. Thank you.
Thank you.
Hi, I'm Yağmur. I'm from Turkey, and I'm in my last year in law school. A law firm that I interned for specialized in intellectual property, and that's about it in my experience.
Okay, very good. Thank you.
Hi, I'm Bio. I'm from Thailand. I'm studying in law third year, and I have no experience in IP law, but except studying in my university. But I'm really interested in and looking forward to discuss. Yeah.
Okay, wonderful. Thank you. Very good. Okay, so I hope this course or this lecture will be interesting for you. I tried to cover some of the basics, but later on in the presentation we will get to, let's say, more heavy stuff, more legal focused. So let's start. What really is intellectual property? So I think in order for you to understand the content of the lecture, I think it's good that we go through the basic terms and concepts. So what intellectual property really is? It is an intangible creation of human intellect. So as such, intellectual property cannot be touched. It's a concept that explains the result of a mental process, you could say. So if you have an idea, you want to create a house, you want to design a house, that is intellectual property in your head until it has been embodied into the building. And that's where we get to the concept of object of intellectual property, which is the house that you have designed. And now you want to protect your house and your design of the house. And that's when you need intellectual property right, which will give you to the legal rights afforded to you as the creator of the design of the building. So these are very important concepts, and I'm going to refer to them later on. So when I say IP, I mean intellectual property, the creation. When I say IPR, I mean the legal right that protects the IP. I have shown here a few images and pictures of items and things that are and can be protected by intellectual property rights. And some of them, perhaps you're thinking, well, what is there to protect? For example, the key. But the key can be protected in various ways. For example, you can have patented solution regarding the technology of the key and how the key interacts with the lock. You have the sleeping bag. Again, what is there to protect about sleeping bag? Well, sleeping bag can have patented protection because of the technology and the material used in the sleeping bag. It can also be protected from a design perspective. It can be some kind of unique design, the way the sleeping bag looks, the combination of colors and the shape. Then there are the more obvious objects, such as computer game. Computer game is a software, essentially. Software is primarily protected by copyright, which might sound odd, but software is actually considered a literary work. It's a computer language. You have garden scissors. Again, what is there to protect about garden scissors? Well, it can be many things. Of course, they can have a name which can be trademarked. They can have a shape which is unique and can be protected by a design. But also, the way the scissors cut can be protected by a patent. So it's very varied. And IP is essentially omnipresent. So it's everywhere around us. I would like to go through the main categories of IP. Some of them you may have never heard of, which is OK, because we're going to discuss it today. So I'm sure everyone has heard of copyrights, right? So copyright, the easy way to explain what copyright is something that you have created, something that is not technical. It relates to a novel that you have written. It relates to a song you have written, a movie you have made, a painting you have created. Trademarks, also referred to as brands sometimes, although it's not accurate. Trademarks protect primarily a name or the brand of a product. So if you have Nike shoes, Nike is a trademark. And the main function of a trademark is to tell you where the product comes from, who made it. So the main function of trademark is to refer to the origin of that good, of that product. Trademarks can have many forms, some which have developed in recent years as a reaction to technological development. So at the beginning, there were only trademarks protecting words and logos, for example. Later on, trademark protection has expanded to protect colors, smells. You can have sound trademarks. And there you basically start overlapping with other forms of IP. So sound is primarily protected by copyright if it is unique enough and creative enough. But surprise, you can also protect sound with a trademark. It's more challenging, but it's possible. Designs, we talked about a little bit on the previous slide. So designs are aimed at protecting the look and the feel of a product. So if I go back to the Nike shoe, Nike shoe can be protected by a trademark, Nike. It can also be protected by design because the sneaker has a very curious, interesting design, combination of colors and fabrics. It can also have some cool, sophisticated sole of the shoe, which was used using patented technology. So again, one shoe can have 3 different IPs in it and 3 different IP rights protecting it. Patents are always relating to technology. Patents protect technological inventions. The main difference between the other previous IP rights is that in order to get a patent protection, and be mindful, this can vary jurisdiction to jurisdiction. In the US, you can generally get patent protection for more creations than in Europe. So the rules are a little bit less stringent, you could say. But the rules remain the same. The invention has to be new. It has to have technological use. So it needs to be possible to apply it in some kind of technological process. Usually, if you want to do patents and practice patent law, you realize that you need further education to actually understand the technology behind it. So a lot of the times you will see that patent attorneys have also studied IT technology, chemistry, pharmaceuticals, because in order to get a patent for a medicine, you need to understand the medicine and the chemistry behind the medicine. Domain names are a specific category of IP. As you know, it relates to the World Wide Web. You can protect your domain names. Usually, what happens is that if you have, again, let's take Nike as an example. You have a well-known, famous trademark, Nike. You want to make sure that nobody registers domain names, Nike.com, Nike.cu, Nike.whatever country. So you register all these domain names, and if somebody tries to hijack or register a similar domain name, your trademark will help you to fight such infringements. Because your trademark, the protection of the name, can help you from letting other people using that trademark also as a domain name. Now, there are some categories of IP that are very specific. They are not widely known. Some of them are limited to certain regions. Typically in Europe, we have geographical indications, indications of origin, and plant varieties. In simple words, this IP protects usually food, alcohol, and plants. The idea behind these rights is that if you have, let's take a French cheese. A producer of a French cheese, let's say they have a family production for many hundreds of years. They've been producing this cheese using the local cow milk and some herbs that grow in the region. They can actually get protection for that cheese so that nobody who makes seemingly the same cheese, but not from the same products and from the same herbs and from the same milk, nobody else can use the name of that cheese. There is cheese called Gruyere, which is a French cheese, and Gruyere has such protection. Indications of origin have a similar function. I'm sure you have heard of Czech beer. So actually, Czech beer is a protected geographical indication. Only breweries which have used local products growing in the Czech Republic and produced using the local water can be called Czech beer. So if you decide to do a franchise to make Czech beer and call it Budweiser, you can't do it unless you make the beer in the Czech Republic. So it's a very interesting way of protecting basically manufacture and production of goods with a long tradition and many years of expertise, and using the local produce because it's the local produce that gives the character to the food or the drink. So the main takeaway, I think, from this slide is that one creation, one object, a bottle of wine, shoe, computer game, can be protected by various IP rights that overlap. They do not conflict, they overlap. And they can exist along each other. And they give you different types of legal protection which complement each other. So essentially, the more IP rights, the better. Now, I thought it would be interesting for you to look at some numbers and statistics related to IP. So in 2020, there was 134 million trademarks filed worldwide. That's a huge number. Top 5 trademark filing countries in 2020 were China, the US, Russia, Iran, and Turkey. So these countries have filed the biggest number of trademark applications in 2020. And these rankings don't really change that much, so probably it's going to be the same in 2021 and 2022. What is very interesting, when I was looking at these statistics, Germans, not the country, but Germans, German companies, have for many years been the number one in filing trademark applications abroad. So German companies like to protect their IP not only in Germany, but in many countries abroad. So they are very IP aware, and they tend to have a lot of understanding of the implications of doing trade and needing to protect your inventions and your creations, also in other countries. If you look at patents, again, top 5 filing countries, we have China, same like the trademarks, US as well. We have Japan. We have South Korea. And EPO is European Patent Office, which basically stands for all European and non-European countries who are members of a patent treaty. We will get to that later. So this is basically Europe. Top 5 countries filing patents abroad. USA, so American companies, they like to patent their solutions abroad. Second comes Japan. Germany is third again, which is interesting. China is the fourth, and then South Korea. When it comes to geographical indications that we spoke about a while ago, as expected, Europe is number one, because this framework originates in Europe. But we also have a lot of these in Asia and Latin America. Oceania and North America, interestingly, comes last. I mean, it's still top 5, so it's still... but this gives you an idea of the numbers we're talking.
Excuse me, as you mentioned that...
Sorry, we need to give you the mic.
Well, as you mentioned that Germans have for many years been filing the highest number of trademark application abroad.
Mm-hmm.
So don't you think that, I mean, that their local registration in Germany will be enough to protect their IP rights?
Very good question, and the answer is no. Because the important fact and the specificity of IP rights is that they are territorial. They will only protect you where either you use the trademarked product or where you have registered your right. When you register the trademark, you get much higher legal protection than just relying on you being on the market and using that brand for a very long time. So if you want to be sure that your German beer is protected also in Poland and in Japan and in New Zealand and in South Africa, you have to file trademark registration in all these countries. Otherwise, someone in South Africa can make the same beer and call it the same way, and you can do nothing about it.
Likewise, these days, if you make any application, that application will be used globally. I mean, so how you are going to protect? Let's suppose if the developer is registered in, example, Czech Republic, so his application is being downloaded and used worldwide. I mean, so what will be the solution for that case?
Sorry, I'm not sure I understood correctly. You're talking about a software application, mobile application?
Yep.
Okay, so this has many sort of levels. So mobile application is essentially software. Software is protected by copyright. You can also have a name for the application, WhatsApp, and you can have a trademark for that name, WhatsApp. The name only protects the name, not the application itself. So if you invent an application in New Zealand, you call it WhatsApp. How do you protect somebody from someone in the Czech Republic creating another application called WhatsApp? Well, you don't really, unless you protect the name WhatsApp in the Czech Republic. And if the software is not protected by a patent, you will have a lot of trouble proving what the technology behind the WhatsApp application is, and that this person in the Czech Republic copied the application, and you will have to sue them. It's not an ideal scenario. So what the big tech companies do, they try to patent the technology behind the applications as much as they can, because then it's much easier to enforce their rights. But again, it's territorial. So you always have to think of where you want to do business, where are you likely, your goods are likely to end up. Is that market interesting for you enough to invest in protecting it? I work for a company called Push Gaming, and we develop software. We have a lot of trademarks to to protect the software. But we don't do business all over the world, and there are markets where we have analyzed it's not worth for us to protect our IP because we do not plan to go there. We do not have enough justification to invest large sums of money and time at this time to protect our IP, but this can change over time. So you basically need to evaluate these things on an ongoing basis and think 2, 3, 4, 5 years ahead. What are your business plans? Where do you want to grow? Where do you want to do business? How likely it is that somebody in those countries is going to infringe your rights? So there is no simple answer to that. It's always a question of analyzing your solution, your IP, understanding what types of protection you can get. What does it take to obtain that protection? And is it worth doing it in these countries or not? Sometimes, of course, you make the wrong decision and somebody shows up and copies your solution, and you need to react to an act rather than doing prevention and take precautions. Because otherwise everyone would pretty much have to register IP everywhere and keep it at all times. It's not viable economically. It doesn't make sense. So it's all about your sort of business plans and your thinking forward and understanding the options you have, but also the risks that there are. I hope I answered your question. So, some more numbers. Now, this is about fake, copycat, or as we use the sophisticated term, counterfeit and infringement ranking. So, counterfeit stands for fake. It's a copy. Somebody ripped off your design, stole your IP. So in 2019, fake goods worldwide accounted for about 3.3% of the world trade, which equals almost $600 billion. And this went up quite substantially since 2013. So you can imagine the size of the fake goods business, $600 billion. Majority of fake goods apprehended during custom controls come from China and Hong Kong, India, Turkey, United Arab Emirates, Singapore, Pakistan, Egypt, Thailand, and others. It's a very interesting perspective now. Because on the previous slide, we saw that some of these countries were number ones in filing, protecting their IP. So you see there is a little bit of conflict here. If we look at it from a different angle, countries typically most affected by fake goods imports are European countries and the USA, France, Italy, Switzerland, Germany, South Korea, the UK, but also Japan. On the right, we see a little chart which shows, from a global perspective, what are the most affected industries. You can see that footwear, 22%, is most likely to be fake. So 22%. Clothing comes very near, 16%. Leather goods, electrical equipment, watches, and so on and so forth. Now a little bit close up on the EU, since we saw that Europe seems to be mostly affected by the global fake trade. In EU, the statistics are slightly different. So the industries affected mostly are, interestingly, toys and games. So you go to a toy shop, and probably a good portion of the toys there are copies of the original toys. Fake Lego, fake Barbie doll, whatever. Watches, of course, fake Rolex on the market. You see that everywhere. And then again, footwear, leather goods, also perfumes and cosmetics, and tobacco, which is dangerous. Now, top 5 pharmaceutical products. Fake antibiotics, fake sexual impotence treatments, or the blue pills, painkillers, strangely anti-malaria drugs, and diabetes treatment. So obviously, as you can imagine, fake medicine presents a huge risk, not from an IPR perspective, but from a health protection perspective. And this is due to a lot of medicine nowadays being available online. So I think we can move on to the legal protection of IP. So I just want to give you a little bit of history of IP laws. I have reduced it to the 3 main categories: trademarks, patents, and copyrights. So according to historical sources, the use of trademarks was first noticed with bakers who used to attach on their bread a stamp of origin. So this bread comes from this baker, and that's the first trademark. Interestingly, this was, of course, used for other products, but somehow the bread plays a prime role. But they would attach similar stamps to pottery and other products, leather goods, right? The first proper trademark law in history was the Baker's Marking Law, enacted by the British Parliament in 1266, so many years ago. The modern trademarks law, though, were adopted mostly during 19th and 20th century. When it comes to copyright, it seems that the Statute of Anne from 1710, again from England, is the first piece of copyright law, at least in Europe and the USA. Quite late comparing to trademarks. In 1886, and we will get to that a bit later as well, the Berne Convention was signed, which set the basic principles of copyright law and the minimum standards for legal protection of copyright works. And this convention is extremely important because most of the civilized world signed this convention, and it basically ensures that whichever country you go, you will more or less have the same legal protection as an author of copyright works. Patents, again, according to historians, go many years back, even before Christ, as we refer to it. However, the first patent sort of legislation was the so-called Venetian Act Venice as in the Republic in Italy. 1474, articulating the needs for the protection of inventors' rights. Followed by 1623, England's Statute of Monopolies, which first introduced the requirement of an invention to be new in order to get legal protection. Again, patent laws, of course, continue to develop, and a big milestone was in the 70s, in the 1970s, where two main patent international treaties were signed. One of them, the European one, mentioned before, and the International Patent System Treaty were created. Now, going more into the merits. So, how to sort of describe and define IP laws? What are they? Where are they? So we have so-called primary legal framework. So something like Copyright Act, legislation that specifically addresses protection of IP. But you also have so-called secondary or supplemental legal framework, which does not expressly deal with IP rights. But somehow, you can use those laws to protect your IP. It's like a secondary sort of backup, you could say, backup solution. Depends on the jurisdiction and country where you come from, but in the European and common law sort of culture, we refer to these laws as the laws of passing off or laws of unfair competition. So where can we find these laws, and what form do they have? So like we mentioned before, we have a lot of international treaties. We have national laws, federal laws, state laws. So there is the territorial dimension. We also have the division between substantive law and procedural law. So substantive law is the act, which says trademark is this and this, and it is protected like that and that. But you have procedural laws, which are very important because they tell you how to enforce the IP rights. We also have hard law and soft law. Hard law would be the statute, the Trademark Act, the Copyright Act. But you also have soft law, like all kinds of guidelines, recommendations. There is a number of IP-related international organizations and associations that issue recommendations and opinions. And the community usually tends to abide by these recommendations, although they are not, strictly speaking, binding. And then, of course, again, depending on the jurisdiction, in some cases, case law can be an actual source of law. In other times, in other cases, case law is just a point of reference. But you have the distinction between statutes and case law. Case law is very important in Europe, in the EU, because we have the European Court of Justice, whose decisions are pretty much binding on the national courts. Now, I would like to talk a bit more about the international dimension of IP laws, because I think it's extremely important, and it's a specificity of IP laws, I would say. There is an extraordinary number of international, regional, and bilateral treaties in place. The World Intellectual Property Organization, called Wipo, or referred to as Wipo, administers most of them. There is 26 treaties administered by Wipo alone, and we have the World Trade Organization that also administers a few of them. And the reason is why? Because IP and protection of IP is all about global trade, because everyone who has invented something wants to sell it, but they also want to make sure that it's being protected where they do business. So the international trading community realized that it's in the interest of everyone to have these treaties and ensure some sort of uniformity and harmonization of laws across the globe, pretty much. For obvious reasons, international treaties focus on the substantive law matters, so they don't typically govern procedural matters, how you enforce, but they give you guidance how the enforcement should look like. But they really do focus on saying what IP is and how it should be protected and setting minimum standards. You also have a lot of regional treaties that are limited to continents or geopolitical regions. So you have the EU, of course, but you have also similar treaties in Africa and Latin America and in Asia. So you could say that the international IP treaties are really the foundation of IP laws. Their aim is to unify and harmonize protection worldwide, and the objectivity of this is to promote creativity and to facilitate global trade, because without global protection, you cannot do global trade. As a continuation on this topic, some of the treaties have actually created framework for international protection. They created a system for facilitating and simplifying the process of getting IP protection worldwide. The best known system is the so-called Wipo Madrid system, which essentially allows you to file one single application and get protection, theoretically, in all member states, which last time I checked was 128 countries. So you file one application and you get protection in 128 countries. Of course, it's not as simple as that, but it is one filing. Similarly, with patents, you have the patent treaty and you have the European patent system, again, allowing you, with one filing, to apply in 156 countries in case of the patent treaty, and in case of the European patent system, 38 countries. So this obviously is a great thing, and it facilitates and simplifies for the businesses to get their protection worldwide without having to go in each country and file 38 separate applications. They only have one. So there's a lot of cross-border and global character to the IP laws. It creates some kind of ecosystem almost. And it exists at the same time sort of parallel next to the national system. So you can file an application using the Madrid system and get protection, let's say, in all of Asia almost. But you can still go to China or to Taiwan or to Korea, and you can still file nationally as well. So there is no conflict. It exists together. In order for these systems to work, it's very important for the countries, the member states, and respective trademark or patent offices to constantly communicate and align and harmonize the actual process around the application. So if you do use these systems, it's very important to understand how each country sort of put this into works. How do they implement the treaty? Are there any specificities? Some countries take a bit longer to process this international application. So you always need to know. But as a whole, the system works, and it's extremely efficient. It's also cost efficient, because the fees for filing in these 100 countries, if you had to go to those 100 countries individually, the cost would be probably 5 times bigger. I've prepared here a couple of slides to explain to you and show you how broad IP law actually is and how much overlapping with other areas there is. That IP law is not a standalone area. It's actually part of many other areas. So let's start with the more obvious areas. We have general civil and commercial law, which provides and defines basic concepts such as property, ownership, damages, civil liability. All of this you need to understand in order to practice IP law. You also have contract law. You need to know how to draft contracts because you might need to sign an IP transfer agreement, an IP license agreement, or some kind of coexistence agreement when there is a conflict between two businesses wanting to work together. You have litigation and enforcement, because if you don't know how to enforce your IP rights, then it kind of loses the point, doesn't it? So you should understand how infringement disputes in IP are handled, what kind of enforcement actions you have at your disposal, how to file a lawsuit in case somebody infringes your IP. There is also administrative law, law that defines how you approach the patent and trademark offices, what kind of actions, what's the procedure for filing an application, or if you want to file an appeal because your application was rejected. You have to understand how to communicate with the offices. There is competition and antitrust law, which is a very interesting sort of area for IP. Because while the objectives are generally the same, there might be cases where IP and antitrust are in a clash. They conflict, they fight each other. They have different objectives at that point. And mostly you will realize that actually competition and antitrust law overrides IP law because there is public interest in antitrust law. Antitrust law is about regulating healthy market conditions, and that is more important than your IP. So understanding this area is extremely important. It will mostly be relevant in cases like licensing and distribution of IP, agreements between big players about sharing technology and creating dominance on the market. And this is, the dominance is, it's the breaking point where antitrust law takes over, because we don't like to have dominance. Because in the end, it's the end consumer who suffers from dominance. Who is dominant can set prices, can divide markets. We don't want that. We also have overlap with corporate and M&A laws. Imagine one business owns IP and wants to sell it to another business. You need to understand the implications of selling IP as part of the transaction, the things you need to look into, the due diligence you have to perform on the IP before you sell it. How do you set the price of the IP? There's labor and employment law, which sounds a bit random, but actually it's extremely important as well. Because a company, how do you develop IP? Well, you need the individuals, you need the people, the employees to develop the IP. How does the company end up owning the IP if it was created by someone else, you? And there are laws governing this relationship. We have tax and accounting laws. Because IP, essentially, is in the end of the day, it's some kind of value. It's an economic value. You need to understand the tax implications of licensing the IP or selling the IP. Or maybe you need to value the IP before you sell it. You need to understand the price tag that you can put on it before you sell it. And this is where accounting and tax comes into play.
Excuse me, as you just mentioned that about it has an economic value and it will be having some tax applications.
Yes.
So which international country has a friendly environment where you have less tax liabilities to register an IP like as an international provider or something?
So normally, registration of IP alone will not trigger taxes. But what triggers taxes is, let's picture an example. You own some IP and you have a business partner who likes your technology and wants to license it from you. So you license this IP to your business partner and you get money in return. You get income. And that income is taxed because it's an income. So basically you need to understand the income tax implications in this particular case. if you're selling IP, you need to understand what kind of taxes the particular country applies on the sale of companies' assets. This is very, very different country to country. I'm not a tax lawyer, so unfortunately I can't tell you which country is the best, which country has the best rates. But usually countries that like to sort of support, enhance business and R&D, they would typically have lower taxation because it attracts business, to do business, to sell, to license. So I know from the top of my head that, for example, Estonia or Bulgaria have low taxes. But there are many more countries that I'm sure have special regimes, and they can be specific to actually IP or research and development areas, that there will be exemptions or special tax regimes. So this is very, very individual. Media and advertising law or entertainment law. This is, of course, relevant because nowadays we have social media. A lot of the IP gets put out on the social media. And you need to understand that environment to understand what you can or cannot do and what are your legal sort of tools to protect your IP. Criminal law, not all countries have this, but I know of a number of countries, including the Czech Republic, that actually has criminal liability for IP infringement. So if you sell fake Nike shoes in the market around the corner, you can actually go to jail. And this is, of course, a very efficient means of enforcing the IP rights. France has very strict rules. I believe they even have criminal liability of businesses for IP infringement. Then, of course, we have IT and software law and e-commerce in general, so online, sort of commerce online. Now, because we live in a digital world, most of the IP is being shared, sold, offered, marketed. It's all happening online. It's out there on the internet. So you need to understand this side, the technology, the rules of that market to be able to advise your client to understand. I can give you an example. I was just looking into something recently for a client. They were using some graphics from a page. They downloaded some graphics and wanted to use it on their product. And they forgot that they need to actually read the license terms that are on the website. You can't just go on the internet, download something, and think it's OK to use it. Right? So you need to do your research. You need to understand that things on the internet are not for free. Pharmaceutical and life sciences are very important because a lot of IP there protects medicines, medical equipment. There's a lot of money and a lot of IP in this area. And of course, an infringement in this area can have serious consequences on your health. We were talking about fake antibiotics, fake medicine, but of course you have fake medical equipment, machines used in hospitals. So for pharmaceutical industry, IP is extremely important. And finally, we have laws around consumer protection and unfair competition laws, which we mentioned before. So this is one of those laws that are more supplementary, but they are quite important. In some jurisdictions, you can actually rely on these laws in case IP laws do not provide a suitable legal tool. They also define the basic principles of fair conduct in business, both among consumers and also among businesses and vice versa. So when you think about all these areas, IP law is part of all of them. And like I like to say, a good lawyer understands this complexity and can identify when IP law spills over into these areas. An excellent IP lawyer understands all of these areas and can actually advise on the implications. So something to think about when you are considering doing IP law, how wide it can actually get, and that you cannot look at it as an isolated bubble or like a niche area, as it sometimes IP law is called. So we talked about overlapping within IP law. But I also want to illustrate that IP itself, intellectual property, has a very fluid and overarching nature. It's also very interdisciplinary. And it has a very strong non-legal side to it. There's also the economical angle. Value, essentially, IP essentially is a value. And that value can grow considerably because, for example, you have excellent marketing team and it just becomes viral and your IP suddenly is worth millions. So you need to understand marketing, economics, tax. So you can consider, if you really want to do IP law and you're interested in a particular area, for example, fashion law, things about designing clothes and how you can protect those clothes. You actually want to understand the industry itself. You want to understand how dresses are designed. How does it all work? Or you like patents, you like software, mobile applications. Well, in that case, maybe you want to consider taking a course in how these applications are made to be able to actually see inside and understand what it takes to develop an application. Or you want to get an MBA or an accounting degree because you want to know what are the tax implications, how to value your IP. And so much more. Or you can hang out with musicians or artists who will tell you how things work, how a movie is made. I have a friend, for example, she's a musician. She makes music for movies, and she also makes music for herself. She produced a few albums. And it was very enriching for me to talk to her about how the music is made and the kind of people she has to deal with and the way the producers of music are pushing her around in order for her to give up her rights for royalties. So the more you get into these things, the more you investigate these non-legal areas, the better you understand, the better your advice, the more targeted your advice. It's very valuable for the client.
Well, as she has, has written or sung many songs, so she has to get the copyright for each single song, because might be, let's suppose she has done, 100 songs, so she has to get, different 100 copyrights for all songs, or one copyright will be enough for all songs?
So the way copyright works is copyright protection is generally informal. What it means is that you do not need to go to some office, bring your song, and register it and get a stamp on it. It doesn't work like that. You obtain copyright the moment you have written the song. Even if that song sits in your drawer, you have copyright on that song. Of course, if nobody ever finds out that the song exists, then it's hard to enforce it, but it's there. And if somebody 2 years later writes the same song, you will take your song from the drawer and say, I wrote it first. So you get copyright on every single piece of creation. It doesn't matter if it's a song, or it's a novel, or it's some drawing you made. So copyright is always attached to the individual piece of creation or work. There is no uniform, one global copyright umbrella or anything like that. It always is attached to the creation itself. So if she wrote 100 songs, she has copyright for each of these songs. Of course, she can put the songs into an album. She can select 20 songs and put an album out. And then it gets complicated. Then there is rights around the recording, because there is copyright on the song and on the words separately. So the lyrics and the music separately have a copyright. If she didn't write the music and the words, she needs to get permission from whoever wrote the words to be able to put that song on her album. Somebody recorded the album. That music producer who recorded the album has recording rights on the album. And those need to exist with the copyright of my friend. So copyright is actually very complicated because you have all these layers of copyright protection, and they very often fight. That's why she called me, because she said, this producer wants me to give up my rights. They want unlimited number of times they can issue my songs, and this and this and that. But yeah, to answer in short, copyright is always attached to each individual work separately. Now, let's talk about practicing IP law. So IP law, in my opinion at least, is a very cool area. It's my favorite legal area. It was love at first sight in the second year of university for me. It's also a very modern area comparing, for example, to real estate. Real estate law has been here for ages. But as we saw, when we talk about history of IP, it's quite new. It's very dynamic as well because it needs to react to the development of technologies. There was no internet 20 years ago, so the IP had to accommodate. There were no domain names 20 years ago. There were no indications of origin for your Gruyere cheese. All these things have developed in the last 30, 20 years, which I consider new and modern. So it's very, very fast developing and very dynamic and very creative because there are all these areas like design, fashion, architecture, music, art. So it's a very creative area. So what are your options if you want to practice IP law? I've picked the obvious and the most typical ones. So I think in the first place, you end up choosing between private sector or public. So in private sector, you can be an IP lawyer in a law firm, or you can be a freelance consultant. You can open your own IP boutique law firm, or you can be part of a bigger law firm. You can also be a trademark or a patent attorney, which interestingly, trademark and patent attorneys in most jurisdictions do not need to be lawyers because they have very limited sort of scope of their authorizations. They cannot go to court. They cannot litigate. But they can go and file trademark applications or patent applications. So you will run into people who practice IP law, technically, but they are not lawyers. But it doesn't mean that a lawyer can't be a trademark attorney, just to be clear. You can also work in a company as an in-house lawyer, company that owns or licenses IP. You name it, Nike, Microsoft, Google, anyone who has valuable IP and needs protection. If you opt for public sector, you will probably end up working for an office like a trademark and patent office. In the US, they also have copyright office. So in the US, you can, if you want, get a stamp on your copyright just in case something ever happens. Or you can work at customs office. That's the one that detains the fake goods that travel across borders. You can also be a judge. You can be a judge that specializes in deciding IP disputes. Or you can be a teacher, a professor in university or whatever. Now, I picked things to consider if you are thinking of studying law and becoming an IP law specialist. So maybe by now you have already understood IP law is very broad. It's actually a very large area. And if you talk to your peers and you say, I'm an IP lawyer, most likely they will ask you, so what IP law do you do? And you end up saying, well, I do patents, or I do trademarks and designs. You will never hear that I do everything, because it's not possible. You cannot master all the areas equally. You can never be good in all those areas equally. So what you realize, people usually pick between 1 and 3 areas, and they become experts. They become really good at it. The most common combination is trademarks and designs. Patent law is a bit separate, because like I said before, you might want to actually study some of these areas like IT, software, chemistry, life sciences, because you want to actually be able to understand the technology that is being protected by patent, not just go to court and litigate. But if you don't understand the subject of the patent, how are you going to litigate and argue? So my advice would be to explore all of these areas and decide what interests you the most and focus on those 1 to 3 areas and become really, really good. Because what you don't want is to know kind of a little bit of everything, but not really enough about something specifically. Point 2, I don't need to repeat, patent law is specific. I don't, for example, do patent law myself, but I've come across patents, and I usually ended up having to outsource to a patent attorney who was a software engineer or a chemical, person with a chemical background, actually understanding the technology that we're trying to patent. In terms of education in your further studies, if you are considering studying IP law or practicing IP law, my advice again would be to not specialize too early. Because you saw how many areas the IP law overlaps with. There's corporate, there's labor law, there's IT, there is litigation. If you narrow down your education very early on, you will not be able to understand all those areas. So it's better to get as broad education as you can, and then later on focus on IP, because by that time you will already know enough about corporate law, about litigation. And then if you really want, you can decide to stay with IP only, but nobody can take away from you that you have done the round and you understand all the areas. In some jurisdictions, if you want to become a solicitor or a judge, you might need more qualifications. You might need to do some training. You might need to do some exam. So of course that depends on where you live and what are the rules to be admitted as an attorney and so on. What is also good to know is that it depends on where you live or where you plan to work. Obviously, in Europe and in the US and sort of the Western world, so to say, IP has been present for many years. There's a lot of specialists. There's a lot of knowledge and awareness, and the market is very competitive. It takes much more to succeed in IP law in a country like the UK or Germany, because everyone knows IP law. There's a lot of judges who do IP law. There's a lot of attorneys, and everyone has very, very good knowledge of IP laws. But if you're in a market that, let's say, is developing or is sort of on the way to be the developed market, there's a lot more opportunities. There is gaps on the market. You can find your niche area that nobody understands, and you can be really good. And you will have no competition, essentially. So also think about that. Do research. How many IP lawyers are there? What do they really do? Does anybody do this or that area? When I started practicing IP law, there were not many IP lawyers here. It was a new area. And I remember my mom was telling me, why would you pick such an area? Like, what is that even? I just knew in my mind that it's something really interesting and really cool. And I keep reminding her till today, you see, I told you. I just had a gut feeling, but I also knew that it's very small and niche area here, but it was big in Germany. Well, what does it mean? Well, one day it's going to come here as well. So think about that as well. If you opt to be a counsel in a company, Coca-Cola, you name it, usually you will find that you need to have a bit of a generalist knowledge. You need to know a little bit about everything. Like we said, there's all these overlaps. And if there will be some sophisticated IP matter, you will most likely outsource it to the specialists, to the law firm or patent attorney. It doesn't always need to be like that, but it's more common unless you work for a company who has 5,000 patents and 10,000 trademarks, and they actually have their own IP department. In that case, you might end up doing only IP because they have so much of it that they need to manage it in-house. Typically, if you work in a smaller firm or institution, your skills need to be more versatile. You need to understand kind of everything. If you will be in a large law firm that does pretty much only IP, you can have the luxury of focusing on one specific area and be like the guru, the expert on domain names or something that's small, but not many people know about it, and you will be the go-to person for that area. You can also decide you don't like litigation, you don't like going to courts, it's not interesting or it's stressful, so you can decide to not be a litigation lawyer. You can decide to do IP only to the extent that there is no dispute. And then when there is a dispute, you hand it over to a colleague who is a litigator and enjoys going to court, or you outsource it. In my personal opinion, I think you cannot separate IP from IP enforcement. So I think a lawyer should not only be able to file the trademark application, but also defend it and go to court and file the lawsuit. So I think it's good to know both and be able to litigate IP. For many people, IP is something very strange, very exotic, very small and niche, and like, what is that? And then there are people like me who think it's the coolest area. So the relationship to IP law, I think, needs to be something like either you love it or it's just like, it's not for me. You can't do it halfway because there is just so much that if you really want to be good, you have to do it properly. Otherwise, you'll realize, you'll start reviewing something and you're like, okay, so there is so much to know, I don't actually want to do it, and you will give it to somebody else. But that's not how you learn. So if any of this sounds interesting for you and you want to continue in this path, I advise you again to learn as much as you can about the different areas and really understand if that's something that could be interesting for you. And if it is, go for it. Finally, one advice, a serious one. If you want to do IP law, do not support fakes, illegal websites for watching movies. It's just not cool because you are the defender of IP, of the values. And then you go and you buy fake Nike shoes. I mean, it's a bit of a mental conflict, isn't it? So, I mean, we've all done that. I bought fake stuff as well. But when I started digging into things and understanding and how much money the clients put to protect and invest and research and develop, and then somebody goes and makes a copy, and me, stupid, I go and buy it, it's just wrong. So think about it. Even if you don't do IP law, don't buy fake stuff. It's not cool. Okay, So now we can have one more short break. And then there'll be a little case study. I can see you're 8, so that's excellent, because we'll have 4 and 4 people. I would like to ask you to sort of decide who will be your speaker or who will present the case. I will show you the case afterwards. And I'll give you about 20 minutes to just discuss. Don't be stressed. There is no right or wrong answer. I want you to think about things, and we'll discuss it afterwards. We'll brainstorm. We'll see how all that we've talked about can be applied to a real case scenario. Okay? So you will need some, maybe paper to write and prepare. But if you can come back the same way you are, and we'll have 2 groups like that. I have prepared 2 case studies. The idea is, like I said, there is no perfect answer to this. So the idea is to trigger your creative and legal thinking, brainstorm together in your groups, and come up with some solutions to the case. Not just the result, but also the way, where did you start looking? What do you think we need to investigate in terms of facts and in terms of what law says? And gradually, it will lead you to some kind of solution or a number of options out of this problem, let's say. So the group on this side, if you can read this case study, and you will have this one. All right? If you can read it, and let me know if you have any questions around the task, if you want something to be explained to understand. All right. Do you understand the... I think it is good to know if you could summarize the case from your side. Okay. So I'll try to translate it, sort of. So let's start with case study 1. So you have a company, your client is a company that just sold some IP, or let's say all of its IP, to a competitor. They just went and they transferred the IP. In your company, or your client's company, the research and development team who made the IP were employees. But somehow, later, it turns out that the head of the development team, the main person behind the team developing the IP, was actually not an employee. He was a consultant, external consultant. He had a contract, consultancy contract, and he was working for this company with the employees. When he found out that the company sold the IP to somebody else, he got interested, he started digging. He realized he was not an employee, and he's saying now, meanwhile the company registered a patent based on the invention he made. And he's saying now that you have no right to sell the technology to this other company because I didn't give you my consent. I was not your employee. So he now wants compensation, he wants money in exchange for giving consent with the transfer of the IP to company B. This information, this problem, it leaked to company B. Company B is all furious. They had warranties in the contract that all IP is clean, everything is sorted, and now they realize that there is this person that can actually challenge their legal title to the IP, even the patent. And company B is threatening to cancel the contract, they want the money back, sale to be scrapped, and it's a huge problem. So I would like you to analyze, see how we can get out of this pickle. what can we do? Because obviously we don't want the sale to collapse just because of this. So we need to find a solution so that company B can enjoy the IP, we get our money for selling the IP, and this problem, this person goes away. We don't want this problem. So what do we do? And the advice I can give you is don't focus on the result. Start with investigating the facts of the case. What does it mean that it's not an employee? Is it really a problem? Why is it a problem? How can we fix it? What can company B do? Can they actually cancel the sale? Do we need to pay them? Why do we need to pay them? So start thinking about all these things, and eventually, hopefully, it will come out, some solution, and then we can discuss together. Case study number 2. So your client, or let's say you're in-house counsel of this company. So your company manufactures some high-tech stuff, some cameras and photographic equipment. They have trademarks. Imagine it's, I don't know, Nikon or Kodak. They have trademarks. They have design protection for the way the camera looks. They have patented technology for the optical lenses. And they distribute these cameras globally. But they have a specific distribution setup. They have only exclusive distribution. So no one else than their own distributors can sell these products on the market. And they split the market to Europe and Asia. There is one exclusive distributor in Europe, and there is 5 distributors in Asia. Now, the client obviously does market controls if there are some fake, maybe cameras, and so on. Accidentally, they found out that a reseller, a multi-brand reseller, so imagine some Walmart or Tesco or some big store, they sell these cameras. On its face, it looks okay. It's original, it's not fake, it's the real stuff. But when they check the labels on the cameras, the product codes, they realize that these cameras were sourced to the Asian distributors. They are not supposed to be in Europe. Why are they in Europe? And to make it worse, this Tesco or Walmart is selling them 30% cheaper than are the market prices for Europe. So this is a major problem, because the company's own branded shops immediately lose clients because everyone goes to this Walmart and buys these things cheaper. Well, of course, 30% is a lot of money. So your client has a big problem. So again, think about all the facts, what you know, what does it mean, and go through the legal implications and avenues to take to somehow help the client to restore the situation, to remove this problem. We don't want these dumping prices. And we don't want, in the first place, cameras that were supposed to be in China or in Vietnam to be in Europe. Because that's why we have the distribution network set like this. Okay? So let's say now it's 10:55. So 11:15 approximately. So ideally talk together, and then one of you will present sort of the ideas you had. Of course, the students online can analyze as well for themselves, and then after see if they were heading the right way. you have any questions, ask me, of course. So I will let you finish there a little bit, but I think we should start. They are ready, so if you don't mind, we can start with case study number 2. So tell me how you went about this and what did you figure out?
Yes. So in this situation, we have a client who has come and told us that the goods are in the European markets, and what do we do with it? So two main options that we see are, one is keeping it there in the European markets, and the second option would be withdrawal, but that comes later.
Okay.
But if we are keeping it in the market, firstly, there was an exclusive agreement with one distributor, and the action of the multi-brand, of the reseller, is a violation towards that specific exclusive right.
Okay.
Secondly, we have trademark, design, and patent, and all of it holds economic rights. And when a certain good is sold for a lesser price, it will affect the economic gains, my gains as a company. So the option would be to restore it to the original price and keep it in the market, and demand for damages that are caused because of the low price or the shaky situation in the European markets. Or the second option would be withdrawal from the...
Okay. And how do you achieve the correction of the price? What can you do? Because it's a third party, so the reseller is not, you don't have a contract with the reseller. So how can you force him to change the prices?
The goods have been sourced from different markets. I mean, let's suppose the goods were prepared in China and the target market was Asia. So there could be a different costing, different overheads. So they are selling, with lower prices. So, I mean, here the resellers have, of course, have a right to sell goods on lower prices as well. However, I mean, if company X has 5 distributors, exclusive distributors in Asia, and if those resellers sell those goods, I mean, below 30%, of course they should not be allowed because they have an exclusive agreement with company X. However, other resellers which they don't have, you know, exclusive right with company X, they are allowed to sell because they are sourcing from different market, and also, I mean, and also goods are not fake, so they have a right. However, now company X have only single distributor in Europe, so he can increase more distribution, he can increase more distributors in Europe to achieve more sales, to protect more sales, to avoid more competition, and moreover, I mean, for Asian market, he has to look at his pricing strategies because he has to compete the other competitors in the market.
Okay. Okay. And then the other option you said that you can remove the goods from the European market. So how would you achieve that? How do you force the reseller to take the goods away? Like, what does he do with them? Because he bought them from someone. He's selling them cheap, but he bought them from someone. So if he had to put them back or get rid of them, he's going to lose a lot of money. So he doesn't want to do it. So how do you force him? How does company X force him to remove the goods from his shop? What can you do?
If there are the 5 exclusive authorized distributors. If those distributors are selling other competitor goods, yes, as per the agreement, exclusive agreement, because they are not allowed to sell other goods. So they have to remove other products, I mean, and they have to sell only X products, as they have exclusive right of selling.
Okay. Okay. Any other thoughts?
I believe that the company X can always litigate to get the to achieve the desired results. As for the question of how do we force the reseller to send the goods back or withdraw it from the European markets, it is a complex procedure because, as you said, they did buy it from somebody, and due to the scarcity of facts, we do not know if they have knowledge whether or not they're supposed to have that goods in Europe or not. Because the way I see it, if they have had knowledge and they still sold it, there arises a liability, and precedents have sort of allowed those people. The precedents have allowed the claimants to seek the removal of goods from those markets, resulting in losses to the violative sellers. But if they did not have the intention, or they did not know about that they're not authorized to sell in the European markets, it is less likely that they would be allowed by the courts to suffer damages and losses, and then also extrapolate the goods back to Asia.
Okay, so you think that the question whether they knew or didn't know whether they can sell these goods could be decisive in being able to force them to remove or stop selling at least the goods?
I think it would be one of the factors, yes. The other factor would be sort of analyzing the extent of damages and losses that the company X has suffered because they have economic rights over their products, and maybe selling their products in the European market, which is supposed to be sold in Asia. I'm just building on facts, but I believe it is possible that there are certain qualities that are more pertinent to the Asian market. It might result even to a loss in goodwill, maybe an unintentional, sort of an attack on their reputation that they did not take on very well. So I do believe that the courts might also look into that and then decide. So I believe these are the two major factors that the courts will look into. Yeah.
Okay, very good. Anything else? It's good?
If we look at, the analysis that the case and advise the client on measures he can take to restore the situation on the European market. Well, again, in the European market, as he has one nominated distributor in Europe, so he to protect himself and to avoid that many like Tesco or Walmart or such brands, start selling those products which are less 30%, as compared to their prices. So they should, sign exclusive agreements with the different market players, so that he can have a maximum market share, and there should be no competition in your market as he is facing in the Asian market.
Okay. All right. So let's leave it there for now. I'm going to ask the other group for their analysis, and then we will go back and I will tell you the solution, or tell you if you were right or not, and which parts were on the good path and maybe which were not going to lead to the solution. So, ladies.
Okay. We came up with a couple of ideas. We don't know which may be accurate or correct.
Can you speak up a little?
Okay. We don't know which one would be correct, but we think that even if a consultant is not an employee of our company, and because he's an independent contractor, it says that a consultant can own the patent to the invention that they make. But if the patent is registered under company A, even if he makes the claim because he's the inventor, he can do that. We were thinking that because he worked through company A, invented this through company A, and worked with, from what I gathered from the description, a team of employees that works for company A, even if he makes the claim that he owns the sole patent to the invention, maybe we can make the claim for joint patent co-ownership. And it says that it doesn't matter how much contribution the co-owners make to the invention, they can still use the patent and sell it without the consent of the co-owner. So maybe we can, even if he makes the claim, we can go to the co-ownership direction, maybe. And that way, there wouldn't be an issue regarding the SPA, because we do have the rights as company A to sell the rights of the IP. It was one idea, maybe.
And what happens if he actually goes? So the patent is registered in a patent office, yeah? In Germany, let's say. This is all in Germany, just for the sake of explanation. So he goes to the German patent office. He is convinced he is right. So he goes to the patent office and he files an action to challenge the ownership of the patent by company A. So he actually hires a lawyer and he goes and he does it. So even though he's maybe not right, and maybe you are right, you have this problem. Company B is freaking out because they bought this patent for a big portion of money, and now they have this person who hired a lawyer, so he probably thinks he has a good case, and he's threatening the validity of the patent or the owner of the patent. So you're in a position that you don't actually have time to investigate or prove if there is joint co-ownership or not. You need to deal with company B, who bought the IP from you, and they are saying, well, we don't care if he owns half of it or all of it. This is a mess, and we want our money back. So what do you do with that? What do you think we can do there?
I think, first of all, we need to get along with the consultants, because in this case, we are the lawyers of the company A, and we don't want to lose the company B, and we want the agreement is still valid between us. So I think maybe we can change the agreements between our consultant and add an article that says we are including the IP rights also, and or we can make another treaty between the consultants, and we can pay some amount to the consultant that we are getting from the company B. Also, if we don't make a treaty, we can suggest that we may make a compensation and pay some amounts for you. So I think we can make an initial agreement.
Let's give him money and shut him up.
Yeah.
Okay. Well, it's a solution, of course, always. But there's also, because one thing is that you shut him up, you give him the money, right? And then there is the company B who is saying, well, you guys sort this out, or else we pull out of the agreement. But we still want contractual penalty because you said you own, you gave us a guarantee that you own 100% of all IP, and clearly you don't. Do you think you have to pay it?
I don't think so, because when we're making an agreement between the company, when making an agreement with company B, the company B doesn't know the inventor is like consultant, and they didn't get the IP rights because of the owner of the IP. They did the agreement because they want the IP rights. So I think it is not fair to give a reason that we want to be breach the agreement because the owner of the IP rights is not the one as you mentioned to us.
Okay.
In my opinion, like maybe we can say to the company B that like we hire the consultant like for R&D team, and in like common sense or common law sense, maybe it's like we can imply that we hire them for making IP. So even we don't have the IP cost in the contract, maybe the company A can like imply that the IP that the consultant make will be like for the company because we hire them specifically for that. So maybe we can claim that to the company B too, that we don't, like we have like honest intent and we believe that that is 100% sure our like IP. Yeah.
Okay, very good. All right, so first of all, I want to say that these are both real cases. This actually happened. So I will go back to the first group and the second case. So let's recap the facts. So we have this photographic equipment. We have the company that produces it has one exclusive distributor in Europe, 5 exclusive distributors in Asia. I see we have a question.
Yeah, I'm sorry. I have an opinion on case 1 from
Okay. Case 1, which was?
Case 31.
Okay.
Yeah.
Let's hear it.
Let's hear it or move it?
Yes, let's hear it.
So I'm not a lawyer, so I do my best. So one of the students from China believed that the consultant company owns the identity. The company owns the identity right of this IP, but it is only some design meant for the company. So the company economic right of the work made by the consultant company should belong to the company, and the company's right to use its works should also belong to company A. However, the consulting company only designed and used the work for company A and did not consider selling the work to make money. Therefore, when the transaction occurred, the nature has changed, so the consulting company should get corresponding compensation.
Okay, that's an interesting view. Thank you. We will, I will include it in the analysis. So,
okay.
So back to case study 2. So we have this exclusive network. Yeah, we have in total 6 distributors. When we say exclusive distributors, the idea is that these distributors do not further distribute. They supply directly on the market. So most likely, these distributors will have one or several shops that are partner shops, or they own the shops themselves, and then they source these products into those shops. So we should, under any circumstance, not in Asia, not in Europe, we should not have a situation where somebody else who is not related with the distributors is selling these goods. So what I want to say is that the fact that these Asian goods are somewhere in Europe, it doesn't matter who sells them. That is the first problem. Because what it means is that one of these Asian distributors has some side hustle. He's selling it to someone who then brings it to Europe. So that distributor has breached the contract with company X. That's first problem. So you need to find out who did it. Which one of these 5 distributors probably sold these goods on the side for some kickback, yeah? So you need to find who this was, and you need to terminate the contract with that distributor to prevent further damage. So you need to cut him off. So that's the first thing you should do. But that, even if you do that, even if you find him and you do that, you still need to get rid of those goods, because maybe there is a lot of them in some warehouse. You don't even know where. So assuming he doesn't tell you to whom he sold it, you're still left with very little, because you still need to approach the reseller and somehow make him stop selling these goods. Maybe he has enough to be selling them for the rest of the whole year. They are not fake, so you cannot go to court and claim he's selling fake goods, because that would be easy. You would go to court, get some injunction, stop selling goods, they are fake. So let's go, excuse me. Let's look into how do we know they're Asian goods. So exactly for these scenarios, company X has developed special codes to label. So the European goods have a different label. It starts with an A, for instance, and the Asian goods start with an X. So that's how they found out. It's some barcode that nobody would really notice. And maybe the reseller doesn't know. But I think he does, because a fair person would question if somebody would offer him these good quality original goods for such a low price. I mean, there must be something wrong. So even if he doesn't know, he should know. So in terms of liability, you basically would probably refer to this as gross negligence. He should have known and he must have known. So it's almost borders with intention. So in terms of liability, I think in most jurisdictions, you would be able to find some kind of liability of the reseller. But again, this liability is only good if you have actual legal tools to go to court and stop him from selling these goods. Now, there is something that you probably are not aware of, and I picked this case on purpose because I think it's quite outstanding. There is something that is called exhaustion of IP rights. What it means is that, and it's, I would say, applicable globally, but there are deviations on a regional level. EU specifically has a sophisticated framework to deal with the exhaustion rights. But what it means is that once you put on the market original goods that are labeled with a trademark or they are protected by a patent, any IP, once they are legally with the consent of the owner, so with the consent of company X, once they are on a particular market, you cannot prevent somebody taking those goods and start reselling them, for example, through an e-shop in that same market. That's why it's exhaustion rights. The rights get exhausted the moment they are put on the market, because it would be unfair. So you have company X that puts goods on the market. So if these goods are the correct goods that come from Europe, this reseller would be fine. He can do that because they are goods intended on Europe and he bought them from somebody who imported them legally in Europe. But the problem is they are from Asia. And company X did not consent to them being brought to Asia because they have a completely separate channel to go to Asia. So these goods were never physically in Europe with the knowledge and consent of company X. It means that the rights are not exhausted. They were not on the market before, and the company X doesn't agree to it. So the fact that there is no exhaustion means that we can rely on something that is called parallel imports. Parallel imports protect exactly these cases. So because the rights are not exhausted, an owner of an IP, trademark or patent, or whichever, can prevent someone from doing exactly this because the rights were not exhausted. They were not put on the market with his consent. So company, the reseller, cannot be selling these goods. In our case, we have the advantage that there are these labels, these codes, so we can prove that these are goods intended for the Asian market. In some cases, maybe the company is not smart enough to distinguish in this way, so they would have a trouble actually proving that these goods were supposed to be in Asia. But we have these codes, they were not removed, they are engraved or attached somewhere invisible, so even the reseller doesn't know the codes are there maybe, but the company does. So we have gotten rid of the distributor that breached the contract. We fired him, we terminated him. Now we have only 4. We reviewed all these 4, they're all good, they check out. We have the reseller who is selling these goods and shouldn't be. We still don't know who sold it to them, but what we can do, because we have not exhausted our rights, and the rights regarding parallel imports allow us to go against somebody who placed on a market an IP-protected item which we did not consent to be in the market. And basically, the legal situation is almost as if the goods were fake. You have the same legal tools. I represented client X in this company, in this case. What we did is we went to the shops, to the reseller shops. We took photographs. We bought some of the items. We brought a notary public to execute a notarial deed evidencing that this company is selling these goods. We took pictures of the stand with the goods. All of this went into the notarial deed. We prepared a lawsuit. We prepared an injunction to the court to order to stop selling these goods. We filed the injunction. In 3 days, the reseller received a court order ordering him to stop selling all these goods and take them from the market. Either destroy them or hand them back to company X. Case sorted.
Well, distributors have also, there's some margin. I mean, company X is selling, let's suppose, $100, so they might have 20% margin or 30% margin, and then they are selling to other companies. So what was the intention behind selling 30% below the market price? It means they are selling at almost cost to cost, or might be even less than, to resell. What was the objective behind?
Well, we actually never found out how it was possible that there was such a big difference, because one theory was that the reseller put the prices real low, wasn't really making any profit, but he did it just to attract the customers. And then he was going to raise it back, maybe 15%. So it would be on the edge of profitability for him. But we think that the idea was that he wanted to steal customers. And once they get used to cheaper prices, they will just always go there. And since the goods were original, it was a very easy and very efficient way of stealing the customers. It showed immediately. So in the end, the client restructured the distribution system. They also agreed with the reseller on some terms to sort of, and not keep enemies. But there was no doubt that the distributor actually knew. And it was just one of the nasty strategies. They did other things to other companies. So it was just part of their modus operandi, kind of how they work. So it was dirty practices. They didn't expect, they didn't know the codes were there. So they were very shocked when the injunction arrived. And this is very, very specific, and it's an extremely efficient tool to stop someone sort of messing around with your distribution network. The challenge of distribution network, though, is, I mentioned in one of the slides, the antitrust and competition law, because sometimes the distribution agreements are drafted and set up in such a way that they actually disrupt the market itself, that they create exclusive monopolies. And in the end, the customer is the victim, because since it's all exclusive, they are able to keep the prices very, very high because they remove any competition. So that's why there is the exhaustion of rights, that if it's within the same market, if it's within Germany, no one can stop you from then buying all these cameras and then resell them again, but not if they were not in Germany already. And that's the magic. They were from Asian market and they were never supposed to be imported into Europe. And that's why this works. It wouldn't have worked if the goods were actually from Europe. Okay? So let's look at the other case. This also happened. I can tell you that the transaction in the end did not happen. It was such a big deal that the company B got scared and the whole sale dropped. But it's a very good case. And then we had similar cases, but we managed to sort of catch the problem before selling the IP. During the process called due diligence, maybe you've heard of it as part of corporate or M&A lectures. So it's a background check that you do on the company that you're intending to buy or on the assets that you're intending to buy. So the fact that there was this consultant who was leading the research team, this should have been discovered, actually. This was an oversight from somebody, from the legal team of, well, both of company A. Maybe company A knew about it, but wanted to, hide the fact. And also from company B, who should have had access to all the documentation. They should have spotted this problem. Because typically, when you do a transaction like this, they should give you a list of the people who worked on the invention and the copies of their contracts as well. So this should have been discovered. So the problem is that this somehow escaped attention. So like lesson learned, if you were ever involved or advising a client on buying or selling, this is something to look out for. In our industry and in our culture, in the Czech Republic specifically, I can tell you that this issue is very common, and it used to happen a lot. It's very common also in the IT industry that companies hire consultants on an ad hoc basis. They don't always have an in-house team of IT software developers. They have, but if there is some big project, they would hire somebody externally. Now, we had the question or the contribution from the students in China. It was not a company that was engaged. It was an individual in his own capacity. It could have been a company, and that would be even more complicated. But it was an individual person who was a freelancer, and he got engaged for this development because it was something big and difficult. So they engaged him to lead the team of the employees. You had the idea of some sort of joint ownership, or, because eventually, I mean, it was a team, so you could say that they have equal rights and that it should be split between the employees and the consultant. The problem is that he really was the brain behind it. They were just assisting him. So in this case, it wouldn't have worked. He clearly was the driver of the invention, and they were completely replaceable. So we had to establish that he actually was the main inventor, and he would have been the IP owner. There is a very specific legal problem here, which actually in Czech copyright law was rectified subsequently because these things kept happening. These consultants popping up, and under Czech law at least, in the past, if you had a consultant like this, he really would have been in a position to cause this problem. He actually would have been. Because under Czech law, only in case there were employees making this invention, in that case, the Copyright Act explicitly says that in such a case, the company, the employer, automatically becomes owner of the economic rights to whatever they create. In case of patents, the Patent Act says that the company becomes the proprietor of the invention, including the right to register it as a patent. So if it's employees, it's all clean cut. There doesn't need to be a provision in the employment contract. The law says it very clearly, and you cannot deviate from it in a contract. But in the past, no one thought about consultants. So it happened several times, and it caused major issues. So there was an amendment to the Act made later, which added a paragraph that now says, in case of work for hire or consultancy, contractor work, in the software development area, so it's limited to actually IT development only. If you hire someone to develop a software program as a consultant, he is considered an employee for the purpose of asserting the IP rights. So basically, in the eyes of the law, that consultant becomes an employee. So if this case happened after the law was amended, you wouldn't have any problem, because the law said it's an employee, even though it's not. But let's say the law was not amended, he was a consultant, he was the main inventor. According to law, he would have only, so according to law, the company A would have only implicitly be granted license to use it for the purpose for which it was created. So it would have been a license, but not ownership. What does it mean? That they couldn't sell it. They could transfer the license, but they would need consent of the consultant. So we actually do have a problem here. And the consultant could have gone to the patent office, claimed that the company A is not the owner. He could have claimed compensation, and he did. So in this case, paying him is probably the best idea, because if he hired a lawyer and he would go to court, he would go to the patent office, he would have won the case. So if this happened before the law was amended, we would have to pay him and settle with company B. We would probably have to pay company B for the fact that we gave them guarantee that we own IP and we don't, and hope that they will not drop from the sale. If this happened after the law was amended, we would have told the consultant, dear consultant, there's this little paragraph hidden in the law that says that you actually are an employee for the purpose of the IP rights. So you have no case. We will give you or not some compensation because we think it's fair, but you don't have a case. Company B would be happy and everything is in order. So I didn't expect you to actually know the solution because it's very specific. It could be different in your countries. But I picked those cases as I remember them very distinctively in my career. They kind of stood out, and it's not something obvious. And it shows very well the complexity of IP law and how important it is to know the related areas of law to understand if this is even a case or not. Do you have any questions? Did you like the solution? No? Okay. Did you like your case? Yeah. Parallel imports, slam injunction, basta.
I had, some other understanding might be resellers which are not, the exclusive distributors. Some other resellers were selling, so they had pretty right, to sell, other brands. But yes, if one of the distributors, among 5, was selling goods, in Asian market, of course, Company X has a right, an immediate relief that he can get from the court. He can get, injunctions, or the action that yes, the court can direct them to stop selling. Of course, this should be the first action from the court, and later they can decide if they can have some understanding, if they can have an agreement. Yes, injunction of relief can be moved, can be released, and then they can move on as per their understanding. Yes, but the first act was required injunction of relief. Yes.
Exactly, and you need to sort of show, the infringer that you're on the lookout and you know how to protect your rights. And in the end, like I said, they came to some agreement, and I believe eventually this reseller was actually selling the original European goods, but they got a favorable price. So in the end, they coexisted and everything was in order, but it had to be achieved through legal action and showing sort of the position of power in the sense that we will not let this happen. But of course, the European framework in this sense is very advanced and very sophisticated. So this was, in the end, a very easy job once we realized that we are able to prove that these goods were actually taken from Asia and delivered to Europe. It might not work in where you live because the laws are different. There are some countries that don't have this. The exhaustion of rights to them is global. So they wouldn't care if it's in Germany or in Asia. They would say the rights were exhausted the moment it was put on the market anywhere in the world. So then this wouldn't work, because for that authority or that court in that country, it's irrelevant that they were from Asia. They were somewhere on the market, even if it's in Bora Bora. It's on the market, and that's it. So you need to understand that this was a case that happened in Europe, and we have European regulations that allow us to go this way. But it's something to remember, and it's very parallel imports, and the whole concept of exhaustion of rights is very commonly used, and it's very, very important for pharmaceutical companies, because as you may know, there are different names and different packagings of the same medicine in different markets. So there were cases in the past that also went all the way to the European court where a company took a medicine that was on the market and they wanted to resell it, which is okay in principle. The problem is that they completely repacked it and they put some different labels, so it was almost unrecognizable. And the owner of the IP to the medicine was actually able to take action against them, not because they brought it from Asia, but because they changed the look of the goods. And one of you had a good comment around reputation and awareness about the brand. That if you change it considerably, you cannot benefit anymore from the exhaustion of rights because you have created almost a different product. It's almost unrecognizable. And that goes against the fair use of IP. So even if you have a license, or even if the law gives you a license to take some good and resell it, you have to adhere to some rules. And one rule is that you cannot substantially change the look of the original goods.
Well, as an IP lawyer, I mean, if you identify the cause behind the scenario, and might be the result would be solved through might be criminal courts or through civil courts. So further, you have to take up to the execution to the courts, or you will recommend your opinion, and then further, I mean, the attorneys who are dealing or handling the litigation in the courts, they will continue the case.
Well, it really depends. Like in this particular case, I did the whole thing. So I analyzed, I went with the notary to the shop, we bought the goods, I was there with the commercial director, we prepared all the evidence, and I actually went to court myself and litigated the case myself. But it's because I have litigation background. So I go to court and so on. But there are, of course, different setups. If you're not a solicitor or an attorney, you can't go to court. So you can analyze the case, but you give it to a colleague or you give it to a law firm that, you know, you gather the info for them and then they go and litigate on your behalf. So it really depends on your experience and how the company works as well. In this case, I was an attorney, so I was not a counsel of the company. We were hired as a law firm to represent the client. All right, so that's it, unless anyone has more questions. I hope it was interesting for you. Yes, thank you so much. And maybe see you around as IP lawyers one day. Do we have any more questions from China? No. No? Okay, very good. So thank you very much. Enjoy Prague.